It's 9 o'clock on Wednesday, February the 16th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Beck, Curcio, Farmer, Griffey, Hardaway, Howell, Lamberth, Moody, Russell, Sexton, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin today? Seeing none, we'll go to our Sergeant of Arms, Mr. Muniz, for the words of wisdom.
Hello, I'm Mr. Muniz, the Sergeant at Arms for this committee today. I'm a proud constituent of the 45th District. Today's words of wisdom are brought to you by Charles Kettering. Believe and act as if it were impossible to fail. Y'all have a blessed day.
Thank you so much, Mr. Muniz. Before we begin with the calendar, we'll go over a few things here that need to be taken care of. Item number 3 on your calendar, House Bill 2177 by Representative Ramsey, will be rolled 1 week. Item number 7, House Bill 2319 by Representative Hall, rolled 1 week. Item number 10, House Bill 2415 by Representative Smith, rolled 1 week. Brings us back to item number 1, House Bill 2656 by Representative Hulsey.
Motion. Second.
You have a motion and a second. You recognize there is an amendment 13468. Do you wish to proceed with that?
There is, and the amendment makes the bill, Chairman, and thank you.
Yes, sir. Were you recognized on the amendment?
Yes, there has to be a law already in place about shooting that gun off up there in a building like this. The amendment makes the bill, and it's House Bill 2656. This is called, actually, Truth in Sentencing. And it's vital to hold violent offenders accountable for their actions while also protecting victims in the public, which is a principle we as Republicans say we believe. And this legislation actually affects 14 particular crimes. I'm going to read them to you. Aggravated assault, vehicular homicide, aggravated vehicular homicide, possessing a firearm or antique firearm during commission or attempt to commit a dangerous felony, attempted first-degree murder where the victim suffers serious bodily injury, aggravated kidnapping, especially aggravated kidnapping, aggravated robbery, especially aggravated robbery, carjacking, aggravated burglary, especially aggravated burglary, aggravated arson, and manufacture, delivery, or sale of a controlled substance, and the person has 2 or more prior convictions of the same offense. This bill says that whatever a judge or a jury gives in the sentencing process, they will serve 100% of that. They can earn credits, but not sentencing credits that will diminish the days in prison. So they can use those credits for other things like a privilege on reducing security classification or other purposes or other privileges in the penitentiary, but they cannot be used to reduce time. Under this bill, with those 14 offenses, you will serve 100% of what the judge or the jury gives you. That's the bill.
Thank you, Representative. Any questions for the sponsor? Leader Lambert.
Thank you, Mr. Chairman. And to the sponsor, I know you've worked on this for many years. I have, and so have many members of this committee. And I want to commend you and our Speaker of the House, Cameron Sexton, as well, for really diving into this and just saying, not only, we had a bill that came through here that I sponsored last week that sets these sentences at where they are now, but this picks out some of the worst criminals out there and ensures that those sentences are raised a bit to the point where they really should be. And I think we had some conversation on that last week because it's embarrassing how quick many of these folks are released from a sentence that they were ordered to serve by an elected judge, in many cases after having been convicted by a jury of their peers in their communities. And it's not fair to the defendant, it's not fair to the victim, it's not fair to anybody at just how low a percentage these folks are eligible for parole. And most of them won't make parole that first time, but it's just this constant back and forth. So again, thank you for the bill, supported 100%, and it really right-sizes many of these sentences on the worst of the worst offenders.
Thank you.
Representative Griffey.
Thank you, Mr. Chairman. Thank you, sponsor, for bringing this. I didn't know, can you sign this co-sponsor sheet, or do I have to get Speaker Sexton to sign that? Do you know?
You know, that's a great question. I do not know.
Well, I fully support this effort by Speaker Sexton. It's needed in Tennessee. We need sentence transparency for the victims and for the public, so the public actually has appreciation of how much time people are actually serving for convicting of an offense. We all respond to the citizens. That's what we're up here to represent, the citizens' wishes, and they need to know the truth, not complicated formula of yes, maybe, well, it depends, and all that kind of stuff. So thank you, Mr. Chairman. Thank you for bringing this bill.
Thank you. Any other questions or comments for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on adding amendment number 13468 on the House Bill 2656. All those in favor say aye. Aye. Those opposed, the ayes prevail. We adopt. We are back on the bill as amended. We do have folks here that would like to provide some testimony. Without objection, we will go out of session. And we will hear from Andrew Brazier.
Thank you, Chair.
Yes, sir. If you would, you can use the podium. You can sit right there, wherever you want to go. If you'll introduce yourself for the record, you'll have 4 minutes for your testimony, and then the committee may ask you questions.
Thank you, Mr. Chair. My name is Andrew Brazier. I'm a faith-based outreach manager for Prison Fellowship Ministries, and I thank you for the opportunity to speak today. I'm here to share Prison Fellowship's position on 2656. And it's an honor to be here today, and I hope that my testimony can help out in this important discussion. Allow me to thank Speaker Sexton's office and also Representative Holsey for generously engaging in a great discussion about this bill. We appreciate that discussion and hope to continue discussing this matter. We also appreciate Speaker Sexton in bringing a transparency and sentencing bill in 2657. As the nation's largest Christian nonprofit serving prisoners, former prisoners, and their families, Prison Fellowship upholds that people behind bars are created in God's image and have God-given potential and purpose. So in keeping with biblical values, the state should promote constructive prison cultures where incarcerated men and women cultivate habits and behaviors that facilitate a productive, law-abiding future after release. Protecting tools that encourage life transformation is an urgent need for Tennessee as it experiences high rates of violent crime, recidivism, and incarceration. For this reason, Tennessee and other states currently incentivize and motivate people to prepare for their future while behind bars. Earned time credits allow prisoners to reduce their incarceration by proactively participating or completing vocational, behavioral, or educational programming. Parole boards weigh that program participation, other evidence, and character development in deciding whether to allow individuals to complete the remainder of their sentence in community supervision. So together, parole and earned time credits promote prison environments where men and women are putting in work towards becoming good neighbors and responsible citizens. As our founder and former prisoner Chuck Colson once said, "Why should an inmate lie on a bunk all day with idle hands and an empty mind? Prisons should require inmates to participate in educational programs and prison industries. Give them a chance to come out as productive citizens and not prisoners." And so with this in mind, we respectfully note our disagreement with HB 2656 in its current form. We appreciate that this bill does avoid wholesale elimination of earned time credits and discretionary parole for all offenses across the board. And while we acknowledge the grave harm that has been done by those who commit the offenses addressed in this bill, 2656 elimination of earned time credits and discretionary parole for selected offenses can undermine critical tools for promoting change behind bars. After all, 95% of prisoners are going to return someday to their neighborhoods and our communities, even if we require 100% of their sentence to be served. Therefore, we should incentivize accountability and improvement through programming to increase the likelihood of successful reentry. Our shared goals of a safer prison facilities for prisoners and correctional officers alike and improved public safety are not well served when incentives for life transformation are eroded. So before further consideration of 2656, we urge you to pass transparency in the sentencing process reflected in 2657, gather data related to all offenses and their recidivism rates, review current sentencing trends across the state and the region, and invest in crime control strategies to keep our communities safe. Parole and earned time credits are catalysts for challenging and changing incarcerated men and women so they will live their divinely ordained purpose and avoid returning to crime. So we urge you and your colleagues to strengthen and protect these active accountability mechanisms through further study of sentencing policies and practices across the state before taking action on this bill. Thank you, Chair.
Thank you very much. Members, do we have any questions or comments for our guest? Chairman Curcio.
Thank you, Mr. Chairman. Thank you for being here today, and
Thank you,
always
sir.
a pleasure to work with you and your organization. And I just want to kind of echo some of what you said, especially, of course, I'm biased because I'm carrying it, but House Bill 2657, you know, providing that transparency, you know, however these conversations wind up, what we know is that victims and offenders both need to know what they're facing. You know, whether the sentences change at all or they change completely. But you know, I hope in that bill we're going to discuss next, you know, at least we can achieve that transparency so that victims and offenders can know what to expect and I think manage their time appropriately. So thank you for your time today. Appreciate you being here.
Thank you, Chair Curcio.
Thank you. Any other comments for our guest? Seeing none, thank you very much for your time.
Thank you, Chair.
For
Thank
being
you,
here,
committee.
speaking with us.
Yes, sir.
We're going to go back into session. We're back on House Bill 2656 as amended. Any other questions or comments for our sponsor? Representative
Thank you,
Halsey?
Mr. Chairman, and I want to echo what Representative Curcio said. I appreciate the work that this organization does and this gentleman does, and I want to be on record that every human being, the only hope for change and conduct is a change in their heart, and that only comes with redemption, and I appreciate your work in that. This takes what seems to be the highest repeats and says, you're going to know what you get, and so do the families. So I renew my motion.
Thank you. Any objection to the question? Seeing none, we're now voting on sending House Bill 2656 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Thank you.
Thank you, committee.
Next item is House Bill 2657 by Chairman Curcio.
Thank you, Mr. Chairman. Thank you, committee. Members, House Bill 2657, you'll see, was brought to me by Speaker Sexton. And what this seeks to do is to provide transparency in sentencing. And so for years, we've heard from our friends at the District Attorney General Conference, we've heard from judges, we've heard from victims to say, well, we say so-and-so gets a 15-year sentence, but with credits, with, you know, percentages served and so forth, it's really not the truth. And so for years, I've wondered why we can't just tell victims the truth, which is, well, it's 20 years at 20% or whatever, you know, the sentence may be. This bill seeks to do just that. It also is the only truth or transparency in sentencing bill that you'll see that has no fiscal note. So whatever happens with these other conversations, whether these other bills pass or they don't pass, this bill will change the way victims and offenders are notified as to what they can expect. So specifically, it says the court, when the court imposes a sentence, it shall place on the record, either orally or in writing, what enhancing or mitigating factors were considered, if any, the reasons for the sentence, and number 3, and I think this is most critical, for a sentence of continuous confinement, the estimated number of years and months the defendant will serve before becoming eligible for release. That's what the bill does, and I request passage.
Thank you. Any questions or comments for the sponsor? Seeing none, any objection? Nope. Leader Lamberth.
Similar comments on the other couple of bills we had on this. I mean, I appreciate you, Chairman, and appreciate our Speaker highlighting exactly how ridiculous the sentencing structure we have is now. Be it this bill, another bill, whatever we want to pass this year, it's not accurate, it's not fair, and it's not honest to people to tell them they're getting a 10-year sentence at 30%, and literally nobody, not the judge, not their lawyer, not the district attorney, not the prison system themselves, nobody can tell them when they get that sentence how long they're going to serve. At least this will tell them the earliest point they could potentially get out, but it just doesn't need to be a rolling date like that. So, I mean, it brings a lot of transparency in, so thank you for carrying it, Mr. Chairman.
Thank you, sir.
Thank you. Mr. Brazier is on our list to testify again. Would you like to testify on this?
Just very briefly.
Yes, sir. We're going to go out of session. We're We're out of session. We'll hear from Mr. Brazier.
Thank you again. Reverend Andrew Brazier with Prison Fellowship. The reason why I wanted to testify on this for 2657 is to thank the speaker and also thank the chair, Curcio, for bringing this because it brings transparency. That we as an organization value transparency throughout the criminal justice process. And so we commend these efforts to make sure that it's clear to victims and defendants alike as to when will be the earliest time for their release, whether or not it's parole or sentencing reduction and credits. We want to make sure that victims know the minimum time the defendant is going to serve before being eligible for release. They deserve to know that. And likewise, defendants should be informed of that earliest possible date so they know what they can do to begin preparing for their eventual release for so many of those who go through our system, regardless if that release is due to parole, sentencing reduction credits, or a work release program for that matter. So we encourage the General Assembly to consider this bill starting with your subcommittee, and we encourage that this committee and the entire General Assembly continue by looking into the sentencing code to focus on the data trends related to increasing sentencing lengths and time served in prison as the Tennessee Criminal Justice Investment Task Force recommended. So we recommend to pass this transparency bill. We thank you for your time. Thank you.
Thank you very much. Any questions or comments for our guest? Seeing none, we're going to go back into session. We're back on the bill, House Bill 2657. Any objection to the question? Seeing none, we're now voting to send House Bill 2657 on the full criminal. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. You move on the full criminal. Thank you. Yes, sir. Representative Beck.
Thank you. I know I'm out of order, but I just wanted to welcome Senator from Davidson County, the Honorable Brenda Gilmore, for being with us this morning. And I apologize for being tardy, Mr. Chairman.
Thank you very much. Item number 4, House Bill 2269 by Representative Ogles. Motion. Second. You are recognized. And before we do that, Leader Lamberth.
Mr. Chairman, I would be remiss if I didn't mention that the good senator is originally from Gallatin in Sumner County. So she's made her way down to Davidson County, but has deep roots in a wonderful community.
So only good things come out of Sumner County, is that right? All right. You have a motion and a second. You recognize Representative Ogles.
Thank you, Chairman, members of the committee. Under current law, a person convicted of first-degree murder while perpetrating or attempting to perpetrate rape of a child, or aggravated rape of a child must be sentenced to either death, life in prison with parole, or imprisonment for life. This piece of legislation would remove the lesser of the sentences, imprisonment for life, and require that a person would be sentenced to either death or life in prison without parole if they kill somebody while attempting to rape them or committing aggravated rape or rape of a child.
Thank you. Any questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 2269 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Thank you.
Thank you, Chairman, members of the committee.
House Bill 1907 by Representative Kiesling. You have a motion and a second. You are recognized, sir.
Thank you, Mr. Chairman and members. House Bill 1907, I want to take you back. You may recall during Governor Lee's first year in office, we as a body unanimously passed an elimination of the state expungement fee. That was led by Leader Lambert, and I appreciate him and his efforts during that time. We recognize that by removing the financial barriers that we can help first-time offenders to get their life back on track. House Bill 1907 would eliminate the $100 application fee for a diversionary program for first-time offenders. Now, please note that diversion is exclusively for individuals with no prior convictions. No prior convictions. Anyone who is a repeat offender does not qualify for this diversion at all. So the fee is currently being assessed to people who are literally seeking a second chance. Mr. Chairman, I can get into the different types of diversions. I can get into who qualifies for diversions and be glad to do that. But I'll pause now if it's you grant that, and I'll entertain any questions, sir.
Well, thank you, Leader Lamberth.
Thank you, Mr. Chairman, and thank you for your kind comments a while ago about my home county. Chairman, I had talked to you beforehand about this. I know the fiscal note on this indicates $906,000 and $906,000 and change. I've had the opportunity, the TBI folks had invited me to come over and tour their expungement facility and meet many of those folks that do that work. For years, we've really not provided the level of funding that they need to be able to process all of these expungements. And this probably will create a bit of an uptick, especially on the front end, of folks that should be able to get an expungement, but that $100 may be a barrier, as you said, at this juncture. Would you have any objection if this were to progress beyond this committee to an amendment that would add 4 additional staff members specifically to help out in the expungement unit at the TBI?
Not at all. That would be welcome, sir.
Thank you. And that's not an amendment I'm proposing today at this juncture, but if this were to be successful in this committee, it is one that I would like to propose between now and the full committee, because I just think that we've gone away from fee-based services with the TBI. I think that's good. And we really need to look at the core mission that they're accomplishing and just fund it appropriately. So, and I want to publicly thank the folks that are doing this job every day. They're literally changing lives. I mean, if somebody is able to get a criminal conviction expunged off their record, it gives them a clean record, and they are able to pursue opportunities they would not otherwise be eligible for. So it's really good work they're doing, and I want to thank the folks at the TBI for doing it.
Well said. Thank you for your remarks, sir.
Thank you, Representative Griffey.
Thank you, Mr. Chairman, and thank you, Chairman Kiesling, for bringing this bill. I just wanted to comment, I wish we would really kind of get away from the expungement model and move to a sealing a person's record. It's the whole purpose of expungement is so somebody can get a charge removed from their conviction record, and so they can apply for a job or whatever, or get a fresh start. I really don't have a problem with that. What I do have a problem with, someone could get an expungement and then commit another criminal offense or something like that. And I don't know that that person should deserve the same protection. If we move to sealing the record and left it up to the circuit judge or general sessions judge, that would give him or her some discretion if future events should merit that. I will say I don't have a problem with your bill. I agree with getting away from the fee for services for the TBI. I also agree with Leader Lambert's comments that I don't think we're funding TBI sufficiently for the mission that we give them and the demands we place upon them. So I would fully support additional staff and additional funding for TBI, but I will vote in favor of your
Thank you,
bill.
sir.
Thank you,
Appreciate
Mr. Chairman.
it. Thank you.
Thank you. Now, Representative Kiesling, I believe that I would be incorrect in saying that expungements will be reopened if there's a new criminal offense. Is that?
That's my understanding.
Okay, that is mine as well. I just wanted to make sure we got that for clarification. Representative Farmer.
Thank you, Mr. Chairman, and I thank the sponsor for bringing this, but I couldn't let this pass by without bragging on the TBI, because when I first started practicing law, what has to happen if somebody's eligible for a deferral or diversion, the court wants to see proof of that. So what we used to have to do, we used to have to get a piece of paper, fill it out, fax it to the TBI, and about 2 weeks later, we'd get a paper back that says either they qualify or they not for a diversion. Well, it basically looked at their criminal history, and that was the proof we needed to give the court. Well, now you just go online, you pay that $100 there, and about $112 there, and about 20 minutes later, it's back, and you can take it, print it off, and take it to the courthouse, and you can just handle all that business in one day. So whatever they've done over there, they're doing a great job, as Leader Lambert has mentioned and others. But I'd be supportive of this legislation, and obviously supportive of giving us more help too. So if they can make things even quicker than what they already are, it's great. So
Thank you for your comments, sir. Thank you.
Thank you, Representative Beck.
Thank you, Mr. Chairman. And from the lower deck down here, I just wanted to thank you, Chairman Kiesling, for bringing this. I know that your heart is to get people back to work, get them on with their lives. And to you and I, $100 would not be a barrier, but to so many people it is.
That's true.
But, and I also appreciate Chairman Farmer and others for bragging on my wife's department with the TBI. And they have done an amazing job, and I thank you very much for that. She is now retired, so the baton has been passed. But we do need to be very mindful of the TBI budget. We put a lot of requirements and duties on them, and they do not get the funding as Leader Lambert said. And so we do need to make sure that we, when we take this fee from them, that we do something to give them the ability to continue this great service that Chairman Farmer was referring to. And thank you again for bringing this.
Thank you for those comments, and thank you for her service as well, and for sharing her with us.
Representative Hardaway.
Thank you, Chairman. Just an amen for Chairman Farmer and for Representative Beck. I agree.
Thank you, sir.
Thank you. Any other questions or comments for our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 1907. Well, I'll retract that. We had someone here that wanted to testify on this. Do you?
Certainly.
No? Okay. Strike that. Sorry.
Okay.
We're going to vote now to send House Bill 1907 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Chairman and members.
Thank you. Next item on our calendar is House Bill 1892 by Representative Haston. You are recognized.
Thank you, Mr. Chairman. This came from County Mayor and County Commissioners, and what this does is for Perry County, it would impose a blood alcohol or drug concentration test fee of $150 and designate the funds towards the county-operated ambulance service. I know that after talking with the chairman and some of the members, I realized that this approach, this one-off approach, is not something that would be a feasible move, and I understand that and completely understand. So I'm at the will of the committee, but with that, I'll answer any questions if there are any.
Thank you, Representative. I do believe this is it's a very interesting concept, and I've had quite the interest in it from my home county as well, because we have a county-based ambulance service. And one of the things that we have that we're struggling with is with staffing. In the past, we've struggled with funding, but now we're struggling with some funding and we're struggling with staffing. So anything that we can do to help, but I do believe it may be something in the future that we can look at as a statewide concept going forward. I do have Chairman Curcio that would like to make some comments.
Thank you, Mr. Chairman, and I really want to thank you for bringing this. I was involved in a conference call over the summer with several folks from this community trying to find ways to get funding. Unfortunately, my in-laws were aging. Unfortunately, they both passed away now over the last 2 years, but I can't tell you how critical those ambulance services were when they would have a fall, when they would have another, medical emergency, and those final weeks of life. We exercise those services quite a bit, and so you don't realize how critical they are until you need them, and the work that's done there is invaluable. So, and we ask a lot of those folks, and we don't really fund them appropriately as a state. And like Chairman Doggett, I mean, I had folks calling from my district saying, "Hey, can we get an amendment to add our county, to this bill?" Which of course we would all love, but. As we've been working through this and talking about this, I would like to propose that we actually send this to TASER for a study on how we can create a comprehensive funding plan for EMS, for ambulance services, to make sure that we finally, once and for all, kind of like the conversation getting away for fee-for-service at TBI, let's fund these folks. They're critical. We all need them. Every one of us has been touched or helped by one of these folks. And so at this time, rather than taking what may be an incremental and maybe even a questionable step from a legal standpoint, I would like to see a comprehensive study from TASER so that this body can take action appropriately next year. So that would be my motion, would be a TASER study for this bill.
We have a motion and a second. Any objection taking a vote on this? You want discussion on the motion? All right. Representative Griffey.
Thank you, Mr. Chairman, and thank you, Representative Haston, for bringing this bill. And I agree with Chairman Curcio's comments. I too want to try to do whatever we can to support. This is a critical function for all of our counties to get emergency medical services, and it's a cost, and they're all facing challenges for that. And I think the proposal to send it to TASER may be a very valuable one, because hopefully get everybody on board and come up with some potential solutions and come back here and look at this. So I would join in, second the motion.
Thank you, Leader Lambert.
Chairman Nason, I just want to commend you. I mean, your folks have asked you to come down and carry a bill, and you've touched on something that, we may be back here next year with a statewide answer on an issue that originated directly with your folks back home. So I want to thank you for representing them strongly and for bringing something up here that, minus them coming to you and you being willing to champion this and push it forward, we wouldn't be taking a big step forward, which, may, kind of have statewide ramifications that will have positive impacts for years. So that TASER study, I'll be really interested to see what it comes out. So thank you for bringing this forward.
Thank you.
Thank you. Any other questions or comments before we vote to send this to TASER? All those in favor of a TASER study on this bill say aye. Aye. All those opposed, the ayes prevail.
Thank you,
Move
Chairman.
to a TASER study. Thank you, Representative Haston. Next item on the calendar, House Bill 1691 by Representative Campbell. Motion and a second. You're recognized.
Thank you, Mr. Chairman and members. House Bill 1691 has to do with execution protocol in this state. This bill came to me from our state's Attorney General. Recently, 2 United States Supreme Court actions indicated that the court frowns upon the idea of excluding a spiritual advisor from an execution chamber. And in one of these cases, the U.S. Supreme Court actually explained that spiritual advisors cannot be excluded because of the Religious Land Use and Institutionalized Persons Act, and that it provides expansive protection for prisoners' religious liberty. So this legislation specifically would change the Tennessee state law that currently says that a priest or minister of the gospel can attend the execution, and replaces that with a member of the clergy. Thank you, Mr. Chairman.
Thank you. Any questions for our sponsor? Chairman Curcio.
Thank you, Mr. Chairman. I just want to thank the sponsor for bringing this bill. I didn't realize that we had limited it to a minister of the gospel, which of course would exclude, a rabbi and any number of other, religions. And, so I think it's a much needed change. Didn't realize that that's the way the code read, and I appreciate good catch. So thank you.
Thank you.
Thank you, Representative Hardaway.
Thank you, Mr. Chairman. Just want to make sure in asking the sponsor, it expands, it doesn't eliminate any of the current permission.
Representative, I think that's a very fair characterization. Yes, sir.
All right. Well, thank you for catching this and curing that gap in the law.
Thank you.
Any other questions or comments for the sponsor? Seeing none, we're now voting on sending House Bill 1691 on to full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you.
Item number 9, House Bill 1922 by Representative Hicks. You have a motion and a second. You are recognized.
Thank you, Mr. Chairman. This issue was brought to our attention by our district attorney in Washington County, and it's simple. House Bill 1922 prohibits sexual offenders, violent sexual offenders, or violent juvenile sexual offenders to knowingly rent or offer to rent a swimming pool, hot tub, or other bodies of water to be used for swimming that is owned by the offender. And that is the bill. Be happy to answer any questions.
Thank you. Any questions or comments for our sponsor? Representative Griffey.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this bill. I wonder if you might describe the problems your DA has been experiencing in their county, what prompted them to seek this legislation.
Sure. Actually, thank you, Mr. Chairman. This is actually going on sort of over the internet and online, that they are advertising to rent out their home or swimming pool for birthday parties for children and stuff. So that's an example of what's been going on in our district.
Thank you. Representative Hardaway.
Thank you, Mr. Chairman. I don't know whether this is for the sponsor or legal, but the Section 1, 2, it is a defense to a violation of this subsection A that the offender was the parent of the minor in the offender's presence. And without having it in context, it would probably be fair to ask legal as opposed to asking the sponsor to try to quote code.
Well, all right, we'll go out of session to hear from legal services.
Michelle Fogarty, Legal Services. That is actually current law under 4039-2015. It's currently subsection B. This bill just moves it up into subsection A so that it applies to the subdivisions A1, A2, and A3, which state that it is an offense for an offender to pretend to be dress, impersonate, or otherwise assume the identity of a real or fictional person, to engage in employment, profession, occupation, or vocation that the offender knows or should know will cause the offender to be in direct and unsupervised contact with a minor, or to operate, whether authorized to do so or not, any vehicle or specific type of vehicle, such as an ice cream truck or an emergency vehicle, for the purpose of attracting a minor. Under current law, it is a defense to those violations if the offender was the parent of the minor in the offender's presence. So this language in Section 1 is just, it's restructuring the statute so that it makes sense, and it's adding a new subdivision, subsection B.
And it would be fair to say it's not adding or subtracting anything from current law, just moving it around.
That is correct. It's just restructuring it.
Thank you, ma'am.
You're welcome.
Thank you to the sponsor.
Any other questions for legal services? Seeing none, we'll go back into session. Representative Griffey.
Thank you, Mr. Chairman. Just listening to legal on this issue and talk with my friend, I wonder, would we be smarter if we prohibited their ability to rent swimming pool or any kind of entertainment devices involving children, rather than banning them completely from renting any kind of equipment or hot tubs or something like that? Would we be smarter if we targeted it as it related to children? And I don't have a problem passing it now. We can discuss that maybe before we go to full or something. I just throw that out there for consideration. Thank you.
Leader Lamberth.
In the midst of what is an extraordinarily serious bill, since Representative Griffey has spoken several times today, I did want to highlight at this juncture that it is his birthday today. So if you wish to wish him a happy birthday at some juncture, he has had another one. So this is his birthday today.
Happy birthday. I do have a question for the sponsor if anyone else does not. Just for clarification of what your intent is, this is referring to a registered sex offender who owns a swimming pool, a hot tub, a body of water that they are renting out to others to come and use. It's not them actually going out and renting a hot tub or a swimming pool. They are creating a contractual agreement with another party to, in return of money or services, goods, whatever, to provide this opportunity for a hot tub, swimming pool, body of water for someone else to come in and utilize that. Is that correct, or did I confuse you with that?
You are very correct.
Okay.
Thank you, Mr. Chairman. Yeah.
All right. Thank you very much. That's what I thought. Just want to make sure. Any other questions for the sponsor? Seeing none, we're now voting on sending House Bill 1922 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full. Next item, House Bill 1911 by Representative Smith. Second. You have a motion and a second. You're recognized. There's an amendment 13598.
That is correct. Thank you, Chairman, and thank you, committee. Thank you so much.
You have a motion and a second. You're recognized on the amendment.
And I will be asking for a roll call vote, Mr. Chairman.
Okay.
This bill literally removes an exemption that already exists in current code. When I look at, I'll draw your attention to 3914-203, and there is it is unlawful for any person to own, possess, keep, use, train any bull, bear, dog, cock, swine, or other animal for the purpose of fighting, baiting, or injuring another animal for amusement, sport, or gain. The code goes on to subsequently list prohibitions on possession of paraphernalia, et cetera. I know that our Mr. Chairman Russell had co-sponsored some legislation just recently. What this bill does, it removes the exemption that's in code except for any offense involving a cock, that all of these other offenses are felonies. This will move cockfighting, any paraphernalia, et cetera, into that same class of treatment. And right now, when you look at how Tennessee treats this particular violation, there are states like Florida and Texas that we compare ourselves to for economic development, for education, for other things where we benchmark. In those two states, this is a felonious activity. And in Tennessee, we export the sixth highest amount of birds for the purpose of cockfighting. And so for that, I know that we want to be renowned for good things in Tennessee, and I think that we want our animal cruelty laws to reflect the best of the angels of our better nature. And so I'll just stand ready to answer questions rather than stand up here doing a sales job. So, but look forward to taking any questions from the committee, Mr. Chairman. Thank you.
Thank you. Do we have any questions on the amendment? Representative Beck.
Thank you, Mr. Chairman. What's the federal law on this cockfighting and exporting and selling and all this kind of good stuff?
Well, I'm sorry. Thank you, Mr. Chairman. Back in the early 90s, there was the Animal Welfare Act was passed federally, and then under George W. Bush, an Animal Fighting Prohibition Enforcement Act was passed, and it made even the movement of animals for the purpose of any animal sporting venture for the purpose of cockfighting, dog fighting, any other type of fighting. So it is a felony, but in our specific code here in Tennessee, we treat it as a Class A misdemeanor.
So you're just looking for parity with the federal law, or would this be the same penalty under federal laws is what you're proposing here in your bill?
Thank you, Mr. Chairman. That's a much more artful way to put it. Absolutely. Thank you.
Any other questions? Representative Griffey.
Thank you, Mr. Chairman, and thank you for bringing this legislation. I think it's important that we do this. Right, currently, it's my understanding if you're fighting dogs, you could face an E felony for that. But if you've got fighting cocks and that's the reason you're doing or fighting them, you could get by with an A misdemeanor. Is that your understanding as well?
Thank you, Mr. Chairman, and that is correct. And further, it is also a federal crime to, possess these animals knowingly for the purpose of breeding them, transporting them, and knowing that they're going to be engaged. And I would like to make it just to read into the record. I know that we have an agricultural state. There are a lot of farmers, and so if you have a poultry business and you are operating legally with all intent of doing your poultry business, this should not worry anyone, but indeed this is for those who are knowingly involved in breeding and moving animals about for the purpose of cockfighting.
Thank you, Mr. Chairman, and thank you again. Look, I would just encourage everyone. Look, we've got mixed martial arts. We've got all kinds of sports, gambling, and anything like that, where humans can engage in just about whatever behavior they want against each other for combat, for sporting purposes. I don't see why we should have to subject innocent animals to this kind of brutality. So it just kind of shocks my conscience. So anyway, thank you, Mr. Chairman. Thank you.
Any other questions for the sponsor on the amendment? Seeing none, we're ready to vote on adopting amendment number 13598. Madam Clerk, take the roll.
Representatives Beck? Yes. Curcio?
Yes.
Farmer? Yes. Griffey? Aye. Hardaway? Aye. Howell? Aye. Lamberth?
Yes.
Moody? Yes. Russell? Sexton? Yes. Chairman Doggett?
Yes.
Chairman Doggett, you have 10 ayes, no nos.
Thank you. We adopt. We're now on House Bill 1911 as amended. Withdrawn. Representative Farmer, Chairman Farmer, you recognized.
And thank you, Mr. Chairman, and to the sponsor. I know I had indicated to you that I was going to be a no on this bill. And as thinking about it, I thought about calling the question and putting it to a vote. But I'd like to know a little more. And let me tell you why. I've been practicing law for about 14 years now. And the first year I was elected here, which is 10 years ago, we made this a misdemeanor. And not one time have I seen in any of the courts that I practice in East Tennessee, which is a lot. I practice anywhere from Davidson County all the way up to Mountain City, down to Chattanooga. Represent a lot of folks who've made some bad decisions, try to help them through that. In not one case have I ever seen a district attorney bring a charge of even a misdemeanor. I don't think it's an issue where I live in East Tennessee, and that's all those counties. It may be somewhere else in the state. If it is, I haven't heard about it. And I just feel like I just don't think there's a need for this. But in order to be clear and understand this better, we'll send it to summer study. I want to make a motion to send it to summer study. So if there are cases of where this has been prosecuted, I'd like to know how many times we're at, what's going. If this is a real issue, let's take care of it, right? So let's find out more about it. So in order to do that, Mr. Chairman, I'd like to make a motion to send this to summer study.
There's a proper motion for summer study. Is there a second? It has been seconded. Any objection to the question? Seeing none, we're going to vote on sending House Bill 1911 as amended to summer study. Madam Clerk, take the roll.
Representatives Beck? No. Curcio?
Aye.
Farmer? Aye. Griffey?
No.
Hardaway? Howell? Lamberth?
Abstain.
Moody? No. Russell? Sexton? Aye. Chairman Doggett?
Aye.
Chairman Doggett, you have 5 ayes, 3 noes.
Thank you. House Bill 1911 will go to summer study.
Thank you. Thank you, Chairman. Thank you, committee.
Item number 12, House Bill 1459 by Representative Hakeem. Your motion and second. You're recognized, Representative. There is an amendment that you have here, 13376.
Motion amendment.
You are recognized on that amendment.
Over the past week, I've had the opportunity to consult in more detail with legal, with members of the leadership of the committee and of the House. And what we tried to do was to come up with policy that is constitutional. And prayerfully, we've come up with that solution. Coming out of the pandemic, there has been a noticeable uptick in violence, period. When you add to that economic issues, emotional concerns, and family disagreements, statistics bear out that we have a problem.
In the area of domestic violence, using 2020 calculations, there were over 70,000 cases that were brought forward during that time period. In the state of Tennessee, we rank 5th in the nation when it comes to deaths after domestic violence. One of the most prevalent of the 14 items that are categorized as domestic violence is aggravated assault. And under aggravated assault, we're dealing with where there was a cause of serious bodily injury, strangulation or attempted strangulation, or use or a display of deadly weapons. And what we have presently in law for a hold period when a person is initially arrested for a violation of criminal justice, domestic violence, is a 12-hour hold. This is at the discretion of the court, the magistrate. What we're asking is that when it comes to aggravated assault, that the court or the magistrate has the option of dealing with additional 12 hours, I mean a total of 24 hours when that person first is arrested. Reasoning for that, some of the reasoning for that, is to afford that person who is the perpetrator an opportunity to cool off or come to a better state of mind than they were originally. Additionally, if there is a person, the victim needs to, I guess I'll use that term, gather their thoughts, their minds, and see the necessity of going to an emergency shelter or something of that nature, 24 hours would afford more so the opportunity for them to do that. So again, what we're proposing is that for domestic aggravated assault, that the court has the option of holding a person for 24 hours to afford opportunity to cool off for the perpetrator and an opportunity for the person who was the victim, an opportunity to think through the process and see what their next step should be. With that, Mr. Chairman, I will endeavor to answer questions as they're posed.
Thank you, Representative. Any questions or comments for our sponsor? Representative Beck.
Representative King, thank you so much for bringing this. I know your heart is, to help families and to help victims, and this is a very good step in going in that direction, because we know you talk to police officers and they'll tell you that domestic warrants and going to domestic violence calls are one of the most dangerous things. It's the most heated interaction that there is, and I just really appreciate you bringing this bill and trying to help victims, help families. Thank you.
Thank you, sir.
Thank you, Representative Griffey.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this, the bill. I've handled a number of domestic violence cases, both as prosecuting attorney and as a defense attorney. My question is, there's so many situations that come up with these domestic violence cases. What happens when an individual is arrested at the home, taken into custody, and then released? Doesn't have his billfold with him, doesn't have his vehicle, he's got to get to work, all that kind of stuff. What are we going to do in that situation? Are there any exceptions for the judge to allow somebody to go get their things, or so they can at least function in life? Because they may be in a location where they don't have any friends or family to rely on. The only person that may be able to rely on is the bail bondsman, or maybe they're even out ROR. So what do we do in that situation? The judge's hands could be tied.
Okay. Thank you, Representative. The best answer I could give you at this time is that actions that are taken by the, I should have a better term than perpetrator, is that at the discretion of the judge or the magistrate or the court. That I believe would be one of those things that they would have to determine on that.
Representative Griffey, what was your question that you just posed? Could you restate that?
My question is, what do we do in a situation where somebody's released and they need to get back to the residence to get their vehicle, their billfold, whatever it is, so they can function in life? And we've got an order from the judge telling them they can't go anywhere within 24 hours. What do we do in that situation? And look, I don't necessarily oppose your thought on this bill, but the current law already says that the judge in ordering release shall order one or more of the following, and that's enjoining the defendant from threatening or attempting to communicate with the alleged victim, ordering the defendant from prohibiting communications, ordering the defendant to vacate or stay away from the home of the alleged victim or stay away from a location where the victim may be. The judge already has all these opportunities to impose this if they want to. And in my experience, most of the time, that's what already occurs if the victim is truly concerned about the defendant being near them and continuing to pose a threat. But there's a number of cases where sometimes domestic violence and the heated arguments between couples can be used as a weapon against somebody to manipulate the situation. There's those situations that occur too in life. So I don't know what your bill may unnecessarily impose additional restrictions that's going to leave somebody stranded and unable to carry on in life.
Representative King.
Thank you, Mr. Chairman. I would only say this deals with aggravated assault, and we're talking about hands being put on another person or the threat of bodily harm. And again, I wanted to ask you, situations like that, how have they been handled? And what we're talking about is that the aggravated assault is the only instance that we identified for that additional 12 hours. Thank you, sir.
Thank you. Representative Griffey.
If we could add, I thought it said domestic assault. I didn't know it was aggravated assault. If I could get clarification from Lee, it is aggravated assault only? Okay. I withdraw my
aggravated domestic assault.
Aggravated domestic, okay.
Which would involve strangulation.
It just said domestic assault on my paper, so that's what I was going off of. So thank you.
Any other questions? Representative Hardaway.
Thank you, Mr. Chairman, and thank you, sponsor, for the bill. If we have to err on the side of caution, let it be on the side of caution where we protect the victim. Domestic violence is one of the, is so prevalent and yet under-reported, under-prosecuted, that if I have to err, I want to err on the side of the victim or alleged victim. And if it causes some inconvenience to the alleged perpetrator or the perpetrator, then so be it. Okay? Justice isn't perfect. We try to get there, but it's not perfect. It's always inconvenient and sometimes a discomfort to one or both parties. But I appreciate you working with everyone who wanted to work with you on the bill, and I thank you for the way you've been able to amend it to address everyone's concerns. Thank you. Thank you, Mr. Chairman.
Thank you. Any other questions for the sponsor on the amendment? Representative Howell.
Thank you, Mr. Chairman. Just for clarification, we're on Amendment 13376. Okay. In reading through that amendment again, my amendment does say in section N, it says person arrested for the offense of aggravated assault. There was some question about whether it said aggravated domestic assault.
Correct. Would you like to go out to legal services and let them
Please.
discuss
I'd
this?
like to clarify that.
All right, we'll
Thanks.
go out of session. Legal services.
Michelle Fogarty, Legal Services. It applies to a person arrested for the offense of aggravated assault in which the alleged victim is a domestic victim under 363601. We don't have an actual offense in code called aggravated domestic assault. We have aggravated assault, and this applies if the victim meets the definition of a domestic assault victim.
Thank you, Mr. Chairman.
Any other questions for legal while we're out of session? See, now we're going back in session. We're back on the amendment. Any objection to the question on the amendment? Seeing now we're voting to add Amendment Code 13376 on the House Bill 1459. All those in favor say aye. Aye. Those opposed, the ayes prevail. We adopt. We're back on House Bill 1459 as amended. Any questions for our sponsor or comments on the bill? Seeing none, I will make one brief comment. Thank you for your work on this. We've collaborated on this for many weeks now. Someone, myself, that sees the need for making sure that we're protecting victims, especially of domestic violence. You give some statistics earlier about how our state ranks amongst others. One of the counties in close proximity to where I live was ranked #1 in the nation for domestic violence murders. Several years ago when I worked in law enforcement. Thankfully, the General Assembly a few years past this provision about strangulation. One of the colleagues here on this dais had carried legislation a few years ago to create the 12-hour hold, to put it in statute, by allowing magistrates to possibly extend that up to 24 hours, I think is a good help, because you're going to have some victims at times when this instance occurs at night under a 12-hour hold at 9 o'clock at night. The offender gets out of jail at 9 o'clock in the morning, and they may go find them at work and do more. They may go back to their home. They may go to the school where the children are. When this happens at night, the victims do not have enough time to get their affairs in order to get to a safe place.
Yes, sir.
You know, you mentioned shelters and other things like that. Sometimes it may be very difficult at 1 o'clock in the morning to get in touch with someone in the shelter, especially if you don't have a means to get there for them to be able to provide that safety for you. And so by being able to extend it up to 24 hours, I think that is a very fair and adequate time that could help a victim seek refuge. And so thank you for your work on this. Any other questions or comments for the sponsor? Seeing none, we're going to vote now to send House Bill 1459 as amended on the full criminal law. Those in favor say aye. Aye. Those opposed, the ayes prevail. Move on to full criminal.
Thank you, Mr. Chairman and members.
Thank you. Item number 13, House Bill 1830 by Representative Lamar. You have a motion and a second. There's an amendment traveling with this 13751.
Yes.
You have a motion on the amendment and a second. You're recognized on the amendment.
Thank you, Mr. Chairman. And I'm going to read the amendment as the bill because it makes the bill. I don't know what you were doing on Christmas, but Artemis Rayford was one of those children enjoying a new game on Christmas Day. He was settling into an evening of fun and a bullet ripped through his home. The bullet struck Artemis, and his mother immediately rushed to him and held him close to her body. Moments after being shot, Artemis was 12 years old and he has died. It is truly heart-wrenching that the story of Artemis' murder is common in our community. And while Memphis in particular gets a bad rap for struggling with gun violence, these issues are prevalent across the state. And according to research, Tennessee has the 14th highest rate of gun violence in the United States. Guns are the leading cause of death among children and teens in Tennessee. Every year, an average of 117 children and teens in Tennessee die by guns. 73 of those deaths are homicides. Every year, an average of 519 people in Tennessee die by gun homicides, and 829 are wounded by gun assaults. In Tennessee, 82% of all homicides involve a gun, compared to 76% nationwide. And over the last year, we have experienced so much gun violence in our community, from the death of rappers to the shooting death of a mother and her newborn baby thrown in the river just 2 weeks ago in Memphis, and a 14-year-old just shot in the neck last week here in Nashville. That is why I am pushing House Bill 1830, the Gun Violence Prevention Bill. This bill is to encourage a multi-agency approach to proactively reduce gun violence in our community, because it is a public health crisis. And I've been able to write this bill where there's not one fiscal note, so it costs the state nothing in order to take proactive preventative measures to reduce gun violence. And I've worked with law enforcement to make sure we got this bill right, because quite frankly, law enforcement is overwhelmed and they can't attack this problem alone. They need others to join into the fight to reduce gun violence. Hospitals are already at capacities. Youth intervention, conflict resolution training is pivotal to stop youth violence, and it's not costing us a thing. So what this amendment does is, one, allow the Department of Health to submit to the legislature and municipalities and counties in this state an annual report on public health impacts of gun violence in local communities. The report must include deaths, disabilities, mental illnesses, and the economic hardships it's costing us dealing with this gun violence issue. It also allows them to work with the Tennessee Bureau of Investigation, who will provide them biannually with incident-level data on gun-related crimes that occur within our state to track hotspots and resources needed to reduce that. Also, we want to attack it on the youth front. If we catch them while they're young, we can change the trajectory of their lives. And so what we want to do is bring in the Department of Labor and Workforce and allow them to create a youth employment program to allow our youth to get off the streets, stop getting in trouble, and make some money for themselves so they won't turn to crime. It also allows the Department of Health to encourage hospital-based violence intervention programs, because oftentimes the hospitals are the first to interact with victims of gun crime. We also want to ensure we are encouraging a gun safety program in hospitals so that primary care facilities are able to intervene when necessary and provide recommendations on ways to keep yourself safe from gun violence. And finally, allow, if necessary, the Department of Education develop a program for children to teach them conflict resolution skills so they won't get in trouble. They learn how to use their words. You know, I was thinking about last year at Cummins Elementary in Memphis, 2 kids got into it, and one went home, grabbed a gun, and came back and shot that kid because he did not know how to handle his conflicts correctly. Again, we can take a multi-agency approach to reducing gun violence. City of Memphis needs it, Nashville, Chattanooga, Knoxville, and all throughout the states, because we are ranked 14 for gun violence, and we want to reduce that in our communities. And this bill costs the state nothing to do that and allow all agencies to join into that fight, collaborate with one another, so we're not working in silos around this serious issue in our community. And that is the amendment, Chairman.
Thank you. Any questions for our sponsor on the amendment, Chairman Curcio?
Thank you, Mr. Chairman, and thank you so much for bringing this. I know it's an incredible problem that we've got to figure out how to tackle at all levels. My wife was asked to serve on the Drivers of Crime Task Force for the governor, on the Criminal Justice Reform Task Force, because she's an elementary teacher, and you know, younger and younger we can identify these kids who are struggling greatly. A lot of it is, you know, poor decisions on their part, but a lot of it is witnessing their parents and the adults in their lives continuing to make poor decisions. And we've created multiple generations of folks who don't know how to deal with their problems any other way than through violence. So I definitely commend you on that. I do have one question. I'm in support of your legislation. I like you, when we have these studies, I like to see tangible results. You know, I want to know, okay, problem, action, result kind of thing. So I just wanted to ask a clarifying question. In Section 1, under 436-101, you say, I think it's the last sentence, so additionally, the report must provide the public and policymakers with research-based information from which to make informed decisions on how best to protect Tennesseans from gun violence. Do you anticipate, or is it legislative intent for this report to actually include like legislative priorities or suggestions, or does that just refer to the data itself and then the legislature can kind of make its own conclusions? I'm just curious what your thoughts are on that.
Just the data themselves, and we have the autonomy to make decisions based on the data that is produced by the Department of Health.
Thank you, Mr. Chairman. Thank you for the bill.
Leader Lambert.
Consistent and really following up on that question and your amendment and virtually everything you said, I agree with. I mean, very good presentation, and I appreciate the tenor of where this is headed to try to just get additional information to be able to combat this massive issue. You've heard me reference several times, specifically in Memphis in that area, in the metropolitan area. It's 346 murders, I think, last year.
342 homicides.
342. And so way, way, way too many people that have been killed by violence, not just gun violence, but violence of all types. In the whereas at the beginning of this, it says it is the intent of the General Assembly through this act to strengthen public health data, and I'm just reading the first parts of these, improve access to prevention, treatment, and recovery support services, all good, reduce the availability and distribution of firearms. Now, that point, I'm hoping that has been somehow misdrafted, that it wasn't your intent to say that we should reduce the availability and distribution of legal firearms to law-abiding citizens. I mean, law-abiding citizens have a right to bear arms in this country. Agreed. It's enshrined in the Second Amendment. It's an individual right. It's just a blanket statement in here to say you would like to reduce the availability and distribution of firearms. I don't think that's your intention. I'd like to hear from you, though, if that is.
Absolutely. So that's not my intention to take away anybody's legal right to own firearms. In the reference to youth, you know, they are not legally able to have firearms under 18 years old. So it is the goal to make sure youth aren't getting a hold of firearms and using them inappropriately. And so, no, the statement, I want to make that very clear, is not to reduce anybody's opportunity who can legally own a firearm, who can possess a firearm. I support your right to have a firearm based on the Constitution, so I just want to make that very, very clear.
Mr. Chairman, if I may ask, is this the first week this has been up in committee, or is it its second time it's been heard? So, Mr. Chairman, I was going to make a recommendation that you roll this a week just to work on that particular point. And that's only specifically for that particular aspect of the amendment, because, again, I didn't think that was your intention to try to indicate either your desire or the legislature's desire to restrict someone's lawful ability to be able to obtain and be trained properly, own a weapon, I mean, for their own protection or just enjoyment, and to use that weapon properly and legally. I would recommend rewording a bit of this some. Specifically, you may want to, if I may make a suggestion, reduce the illegal distribution of firearms or something along those lines. I mean, and make it clear you're going after those criminals that are misusing a very powerful tool that can be used in the wrong way to horrible, horrible ends, but in the right hands, say the hands of a police officer or a well-trained citizen, can save lives. And so it's just the wording of that I think would need to be changed around a little bit. With that, Mr. Chairman, I would make a motion to roll this 1 week.
Can I make a comment?
Okay, that's a proper motion. It's been seconded. Second.
Can I make a comment?
You may.
Is it possible to do a voice amendment? I have 3 guests here to testify on this piece of legislation. I would hate for them to be turned away. Am I able to make a voice amendment to this to change that one line here? Because it's just a wording change, not in the whole intent of the bill is changing or anything.
Mr. Chairman, would it be possible to hear the witnesses this week and then take up my motion at that time so that they can be heard? And then any changes, I know the chairman and staff do not like verbal amendments. I suggested that on a bill earlier and was turned down. So I know they prefer not to have oral amendments on bills. But, Mr. Chairman, I do not wish to push forward with my motion at this time. If there are witnesses on this, I would not want to preclude them from being able to testify.
If you'll withdraw your motion, we'll go out of session and we'll hear from our guests.
Yes, sir, Mr. Chairman, withdrawn at this time with the intent to move that motion again in a few moments.
Okay, thank you. We will go out of session. We have with us today a few folks. We have Dr. Paul Juarez, if he's here. You can come forward. You can sit at this table right here if you like. Representative Lamar will help you get set up there with your sound. Introduce yourself, who you're with, and you'll have 4 minutes for comments.
Great. Thank you, Mr. Chairman and members of the committee, for this opportunity to provide testimony in support of HB 1830. I'm Dr. Paul Juarez. I'm professor and vice chair for research in the Department of Family and Community Medicine at Meharry Medical College, and I've worked in the area of youth violence prevention for over 30 years. I started in Los Angeles at a time where we were experiencing a huge wave of violence, particularly firearm violence, and we were seeing over 1,500 homicides per year. That got me really involved in this because I work with the trauma center and again, just knew we had to do something about this. So as part of that, we established a coalition. We called it the Violence Prevention Coalition of Greater Los Angeles, and and it eventually actually got incorporated into the Department of Public Health of the county as a unit. Since coming to Nashville about 20 years ago, one of the things, again, this has been a passion of mine, and we worked to create I got a grant from the Centers for Disease Control to create a youth violence, it was a coalition to promote youth safety. And through that, we brought together over 100 academic and community partners to address this issue. During that time, the rate of violence actually decreased each of the 5 years that the grant was funded, and subsequent to that, the violence rates just exploded. The youth violence rates went up very high. This bill would build on and codify some of the results that we achieved during that. It would create a public health approach with a focus on prevention. We work closely with law enforcement as one of the partners. We work with the schools. We work with mental health. We work with social service, children's services, and then community partners. And we engage youth in the discussion of what needed to be done. And so I think that, again, what this bill does, it really creates an environment that supports a prevention approach, a public health and prevention approach rather than a law enforcement criminal justice response. Advantages of a public health approach include, again, shifting the focus from law enforcement and criminal justice to one that includes the public health. It also creates new partnerships between public agencies and nonprofit organizations to address the problem of youth violence, again, with very complex causes. You need to have multiple agencies and people working together. Again, the third thing that it promotes is a sharing of data between law enforcement and the health department so that we have better information to understand where it's occurring, who's involved, and are able to better target interventions to those populations. And the fourth, again, and I think is really critical to understand, it would reduce health care costs. Again, the median cost of a hospitalization due to a firearm injury is about $20,000. That's just for one person. And if it results in more complex medical issues or rehabilitation, you can easily, for one person, get into well over $100,000. So again, the issue of preventing youth violence and firearm injury in particular is something that I think, again, is extremely important. And so in conclusion, I urge you to pass HB 1830, which as a state-based solution to preventing youth violence, and I'm available to answer questions at this time or later.
Thank you very much. First on my list is Representative Sexton.
Thank you, and thank you for your approach toward corrective measures on violence. And my question is probably two or threefold. Mm-hmm. In researching and gathering the data that you have gathered to determine what causes these problems, did you or have you looked at these young offenders and whether or not they come from single homes or fatherless homes? Is that part of your data research?
Certainly, it's a part of those who get caught up in a cycle of violence. Oftentimes, again, it's young people, particularly males, that don't have sort of the father figure in the household.
What percentage would you say that would be?
What?
The percentage?
Again, it's probably over 50%.
Is there any part of of your program that focused on the family and the family unit?
Yes, absolutely. Again, working with a lot of the community partners here in Nashville, we had the Oasis Center, which is a youth-based organization. We work with some of the, the mental health service providers. We certainly work closely with the schools to identify, so everybody was working together with the young person to address the issues that arose. So again, one of the problems with just having a law enforcement response is that it doesn't address a lot of those other factors. And this way, we're able to pull together teams of professionals from various disciplines who can work together to address some of those issues.
When a child is conceived, I think that the responsibility should be on the father and the mother, the biological father and mother that had that. And I think that we've taken our attention off of the responsibility of the parents and tried to put more of the responsibility on the community or the school system or things like that. And focusing on violence itself is one thing, but I think the attention that is being drawn to the violence, and I hear this over and over, that it's gun violence. Guns do not cause the problem. It's the perpetrator behind the guns and the responsibility in the homes of whether or not that they're the guardians that they should be. And I think that when it comes to charging people, I think we need to start charging and holding responsible the fathers and the mothers that are not doing the job, that are having these children, and then just turning them loose. I think that those perpetrators that are not fulfilling their responsibility as a parent, they should be prosecuted and they should be put in jail if they're not going to fulfill their obligation of having a child and bringing a child into the world. It's not the community's responsibility, in my opinion, to raise a child. Now, if you've got orphans, I think we have a responsibility. We have children's homes and all kinds of programs to take care of people that don't have anywhere else to go. But I think it's quite too often that we let the fathers and the parents, there's no criminality involved in having the children and then just walking off and leaving it. And I think that's where that we should put the responsibility. And the gun is not the perpetrator. It's the person behind it. Just like drugs are illegal, but we still have a real drug problem in our country today.
Just a quick, can I just respond quickly? The issue of parent responsibility, I think we all certainly agree with that. One of the issues, though, particularly with single mothers, is most of the time they're working outside of the home just to make ends meet. And they don't have the opportunity to provide the type of direct supervision when kids get out of school and that sort of thing. So those are complex issues, and ones that we can help. Again, what we did is we brought together the Parks and Recreation Department, some of the other organizations to provide after-school activities to keep the young people involved in productive activities. So I think those are things that, we have to look at the issue. We have to understand what are the dynamics at play here, and solutions will be individualized to the child and or their family.
And those things are wonderful programs, and I'm glad that we have them. But would you agree with me that the family unit is the best possible opportunity for a child to grow up and have the best education, the best life that they could have, is in a two-parent household?
Well, again, that's the ideal. I think certainly I would agree with that. But I think that the opportunities that are available to youth in many low-income areas in terms of the quality of schools, the level of violence that is in their neighborhoods really creates barriers for them and their families to navigate violence oftentimes. So it's not an easy, there's no easy solutions here, but it's really going to take the collaboration, I think, of many people within a community to help address these issues.
We create a problem that is not a problem if we do it the correct way. and the correct way is through that family unit. Does your programs or anything that you're presently doing, does it teach or foster that the best way to have a child raised correctly is in a two-parent home? Do you do that? Do you teach that?
That's not part of this bill, but it is something that I think, a subsequent bill could be introduced. And I've been sort of told I need to say thank you and wind it up. So, Mr. Chairman, I'd like to thank you and the committee members for this opportunity.
Thank you. Representative Griffey would like to ask you a question before you leave.
Thank you, Dr. Juarez. And listen, I want to commend you for your dedication and effort in this area. And I know it breaks all of our hearts to see our young people shot and killed senselessly across the state. I want to agree with my fellow representatives' sentiments that perhaps the simplest answer and the issue we should all be trying to address and emphasize and support is to bring our families together where we don't have single-parent families. And that's not always possible, and where we don't, I can't think of a better organization to try to address the demands and difficulties that single moms and single dads have would be the church, to try to help raise the children while they're off working. Some people may not have family members or whatever, but to me, this is almost a local community issue that we could bring people together. And the number of persons killed in Memphis this past year, and Representative, I want to commend you for bringing this legislation. You know I love you and you're a great representative. I'm just wondering whether the legislation is really going to fix what we're trying to address. And I honestly, in my experience, and I lived in Memphis for a number of years, and we've had the Memphis Crime Commission that tries to address this very issue, and we've had it now for 30, 40 years. I kind of wonder if we might be better if we took the $668,000 of expenditures and we invested that into our local police in the Metro Crime Unit, because most of the killing, in my opinion, is drug related. It's gang assaults on other gang members as part of the drug trade, and innocent people are getting killed in the crossfire. And we need to address that. And so I commend your efforts, but I think we would be smart if we would try to invest and engage and get our families together and support them and support the family unit. Thank you, Mr. Chairman. Thank you, Mr. Juarez, Dr. Juarez.
Thank you. And I would remind the committee that comments and questions at this time are to be focused towards our guest and not at the sponsor of the legislation, because we are out of session. So thank you, Dr. Juarez. Next on our list is Linda McFadden Ketchum.
Good morning. I'm Linda McFadden Ketchum. I'm a volunteer with Moms Demand Action for Gun Sense in America. Thank you for the opportunity to speak to you today. I'm also a gun violence survivor. My uncle shot and killed my aunt in her bed, and then himself with a gun no one knew he had. A few years later, a close family friend was shot in the head in the Unitarian Church shooting in Knoxville. Thankfully, she survived. In my 9 years of volunteer work on gun violence prevention, I've come to know many survivors. Our state is filling up with gun survivors like me. I'm here to speak in favor of 1830 because it addresses our gun violence epidemic as a public health emergency. In an average year, 1,273 Tennesseans die in shootings, and 2,220 more are wounded. We have the 14th highest rate of gun violence in the country. This is the worst of it to me. Guns are the leading cause of death among children and teens in this state. I never thought I would live to see that be the truth, but it is, and it's shameful. And in our state, an average of 117 children and teens die by guns every year. 56% of all gun deaths in our state are suicides. 56%. And in 2019, 18 Tennessee women were shot dead by their intimate partners. Moms Demand Action supports many parts of this bill, but I want to speak to just 3 of them today. It would require the Department of Health to create an annual report about the public health impacts of gun violence, deaths, injuries, mental health consequences, and the economic costs. It would include research-based information to help us make informed decisions about how to protect Tennesseans from gun violence. It also encourages the Department of Health to create hospital-based violence intervention programs in neighborhoods where there's a lot of repeat shooting. Compared to the general population, patients hospitalized for firearm injuries are 30 times more likely to be hospitalized again and 7 times more likely to die of a firearm injury within 5 years. Hospital-based programs have been shown to reduce retaliatory shootings and recidivism by providing intensive wraparound and follow-up services, including to the family, to people in the middle of a conflict. The bill would require the Department of Health to take gun death and injury seriously by providing non-judgmental gun safety instruction and safety devices such as cable locks in emergency rooms and doctors' offices. Anyone who's spent time down here with this body knows that you like to move slowly, at a snail's pace. I don't mean that in any offensive way, but we're all used to the baby step approach to change. And I get that in ordinary times, but this is not ordinary times. Our gun violence epidemic is extraordinary and big, and it's getting worse. People all over our state, not just in the cities, are dying in shootings. For each of them, there are many others, family members, neighbors, close friends, and coworkers, affected and heart-wounded who need our help. I hope you will take this bill seriously and vote to keep it moving forward. Thank you.
Thank you for those comments. Any members want to make comments or questions for a guest? Representative Hardaway.
Thank you, Mr. Chairman, and good morning, ma'am. Thank you for the work that you and your organization, the work that y'all do. The ability to address the gun violence epidemic, and it is such, is hampered by the lack of good data. Your organization seems to be adept at pulling together some of those numbers. So are you supporting the bill because you know that having all of these agencies engage would give us a better grip of what the actual problem is so we could build data-driven solutions?
Yes, sir. I agree with that. I suspect that some of the data that we need is out there. I've done some digging, and sometimes it's hard to find, but we don't mean to say that the Department of Health isn't doing a good job. There's a lot of good data there, but it's not comprehensive, and we need one report every year, and it'd be a big project, but we need one report where everything is there so that not just you and me, but average people could get a look at what we're looking at.
Yes, ma'am, and the problems are complicated, they're complex, they're so intertwined when you look at the different agencies and commissions and boards that have been trying to address it. The one thing they haven't had is effective communications and cooperation between these agencies and boards. And that's what science, that's what medicine does. It brings all the specialists together so they can get their thoughts organized, get the data, the research organized, and then attack the disease, the problem, the illness in an organized fashion that can cure the problem. So I thank you for your support. I thank the sponsor for the bill.
Thank you, Representative. Representative Sexton.
Thank you, Mr. Chairman. Just wanted to clarify that your organization focuses directly on gun violence. Is that correct?
Yes, sir.
And would it be fair of me to say that you would like to see guns removed from society as being the perpetrator and the problem?
Not at all. Not fair.
Okay. Then can you give me just a short example of what you would like to see as you are focusing on gun violence? What would you like to see?
I'd be happy to. We want to get the death rate down. We support legal gun ownership. We have no problem with guns in the home for protection as long as they're properly stored. We're trying to get guns out of the hands of people who should not have them, like felons, domestic abusers, kids.
And those are already illegal. Felons, it's already illegal for a felon to own a gun.
Correct.
So it seems to me the problem is not gun violence. It's the person that I've never known of a gun shooting someone. It takes a person to pull the trigger to kill someone. And that's where the murder is occurred by another human being and not an instrument. It's the human being that needs to be worked on. And we need to identify the problem. And, you know, most of these killings in these larger cities are youth on youth killing, drug violence, and those things. But when you preface what you're saying by gun violence, it makes it appear that it's the gun that's the problem and not the person or the problem behind the gun. The gun is just the instrument that's used. You can use a knife or anything to kill someone. So we need to be focusing on the problem and where the problem lies and not the instrument that's being used. So with that.
We should have a chat about this. I'd like that. I believe it's the person with the tool.
Representative Beck.
Very good and very quickly. I think and to me, it's the access to guns, illegal guns. Since we've allowed guns in cars and guns in trunks here in Nashville, unfortunately, we have not had good, responsible gun owners, and we're getting hundreds of guns stolen each week that end up in youth's hands, that end up in felons' hands, that end up in the wrong hands. And I think that's it. Every time I've met with you, it's been the access to illegal firearms. Is that sort of where y'all go?
Yes, sir. You're right.
Thank you.
Thank you. Representative Hardaway, you have a brief comment?
Yes, sir. Very brief. And I've worked with moms before, and I think they're in concert with the thoughts of my colleague, and I'm going to kind of sum it up. The goal is to put education and training, gun safety, in a place where responsible, qualified gun owners can access it.
Well, it would be, information is available to all of us, so, you know, anybody could look at it. Hopefully somebody who was going down the wrong road would also take a look, but I don't think we can legislate who gets educated by reports that we generate.
Yes, ma'am, and I'll qualify my statement is in that I do think that everyone needs to have safety training and education about firearms, whether you own one or not. But in particular, those who are qualified and are gun owners need to know what they are holding in their hands and what it can do to another human being or multiple human beings. So I'm in agreement with my colleague, but I want to stretch it a little further. Okay. Thank you. Thank you, Mr. Chairman.
Thank you very much. Our next guest is Mr. J. Lawrence Turner. If you would introduce yourself, you'll have 4 minutes.
Thank you, Mr. Chairman and committee members, for this opportunity. I'm Reverend Dr. J. Lawrence Turner. I'm the senior pastor of Mississippi Boulevard Christian Church Disciples of Christ in Memphis, Tennessee. I'm as well the chair of the steering committee of the African American Clergy Collective of Tennessee. Much that I would have said has already been said by the other two witnesses and by Representative Lamar, and so I want to just jump down to it and first affirm that the strength of the family certainly dictates the strength of any society or community. I do want to affirm that the church is part of the solution, but we cannot do it alone. Also, I've seen that African American fraternities and sororities have done their part in going into schools and communities to mentor the next generation, but clearly that hasn't been enough. We need our state to take bold action, and I believe that HB 1830 will represent our state taking a bold and necessary step to employ a multi-agency approach in combating senseless gun violence that plagues communities across this state. Just as our state has marshaled its resources to combat the opioid epidemic that has needlessly claimed the lives across this state, we can use all relevant resources to carve a new path forward for our state. This bill will not only foster data-driven prevention that helps us identify hotspots for violent crime and offers our children gun safety training, but more than anything, it will equip our young people to resolve conflicts without using a gun or without using their fist. As a pastor, it's heartbreaking to walk with a family as they go through the valley of the shadow of death when a loved one's life has been cut short because of the reckless use of a gun. I've ministered to a parishioner shot while driving on the freeway in Memphis, and how now she no longer wants to leave her home or even drive because of the trauma it has caused. It's demoralizing to see the future generation of our state that is coming on the horizon placed in caskets and in the ground before they can realize their God-given potential. But even worse is to see these things happen and not have a plan to do anything about it. Proverbs 3:27 says this: "Do not withhold good from those to whom it is due, when it is in your power to do it." It's within our power to act in a way that can bring an end to the epidemic of gun violence by taking proactive steps that will clear the way for the next generation to live into the future and the hope that God has for them. We have an opportunity with HB 1830 to make the communities and cities that make up this state much safer and attractive, and to make the future of our young people that much more brighter. Thank you, Mr. Chairman, for the opportunity.
Thank you. Any questions for our guest? Representative Moody.
Thank you for being here. In all this discussion, and since you're on the hot seat, I guess I'll ask you too, but I haven't heard any mention of the studies on the negative influence of music, movies, games, these things that all our youth are so addicted to. And, I know very little. I just hear enough to know that it is shocking, the violence in these games and just, again, the movies, the explicitness of music now. So whether you know the answer or maybe the sponsor, but would that not be relevant to a study and data given how that cultural influence is so strong with our youth? Would that be included in any of this?
I wouldn't be privy to that information, but I do think that this bill speaks to part of its data collection. I think it would be looking at some of the causation that brings about this violence. So I'm sure that might come across the radar on some of this, but I wouldn't be the one who could offer that insight.
And I do want to thank you. I do agree the church is huge. You've got the truth on your side, and I commend you for your work. And my prayers are with you in continuing that. So thank you.
Representative Hardaway.
Thank you, Chairman, and good morning to you, Reverend Dr. J. Lawrence Turner.
Thank you.
I know your work. I know that you minister to not tens or dozens or scores, but to literally thousands every year. Okay? And you understand what I'm about to say. Some of my colleagues have alluded to it. I'm going to say it direct. When we talk about family values, number one, you got to have a family. Number two, you got to have values. I'm not going to speak directly to the family structure, but I will speak to the values. I have family values because my folks had religion, okay? Yep. If you got faith and you're involved with your church, yep, chances are that you got family values. So a lot of the things that we talk about, I think if we look at the data, the statistics, fewer citizens in America are going to church, attending church these days, right, or claiming any specific sect of religion. Right. Would you speak to that, sir?
Yeah, I think you make a very valid point that we're living in an age, even pre-pandemic, where the American church was experiencing a significant decline in church attendance. And so it's a greater likelihood that even if you do have a family with mother and father in it, that they might not be church attendees, right? And so that's exacerbated in circumstances where there's a single parent who's heading up that home. And so it's real, and I think the influence of the church is not what it has been. We are a partner in the fight, but we certainly can't, lift this ourselves.
And Mr. Chairman, when we go back in, I'm sure the sponsor would probably speak to this and inform us that the cultural and those values that we get from our faith are part of what she intends to be studied, and that data will speak for itself. But I thank you, Pastor, for the work you do, and welcome to you and the African American clergy. Y'all do good work. Looking to spend some time doing some Q&A with you later.
Thank you so much.
Sir.
Thank you, Representative.
Thank you, Representative Sexton.
Thank you, Mr. Chairman, and I'll try to be brief. First of all, I want to thank you for your service and the work that you do. I, too, was a pastor for 25 years, and so I know what, you face in those families, and it's heart-wrenching sometimes. And I just want to make a statement that I appreciate the sponsor of the bill and everything that all of you are doing to try to help your communities, and God bless you for that, and we should be that. We can disagree on how to do that, but I think that everything that we've discussed here today, from music and fatherless homes, single-parent homes, anything that's affecting our youth needs to be looked at and see how that we can combat that to raise good citizens and because we're certainly going to need them as I'm getting older. But I appreciate the work that you do. I want to say this. When you focus on, and it seems that this whole discussion has been nothing more than gun violence. It makes me feel like, as a proud gun owner and a proud Second Amendment person, makes me feel like that you're coming after my guns. And that builds a defense. And I don't want to build a defense. I want your community and my community and all of our communities to be better places to live, for our children to grow up, and for us to go to church and to have a good thing. So I don't want to be divided. I want to be united on all of these fronts. But I think sometimes it gets lost. The message gets lost because we maybe disagree on the Second Amendment. And we can disagree on the Second Amendment, but still agree that we want to do the best for our communities. And I believe that's what you're all wanting to do.
Representative Sexton, if I might, I don't think the spirit of this bill, and I think sponsor can speak to this, is attacking gun ownership or the Second Amendment. I think the spirit of this is also something else that is embedded in the Constitution, the inalienable rights that we all have to life.
Amen.
Life.
Amen.
Liberty and the pursuit of happiness. I don't think that's something that should divide us. That's something that should unite us. And I hope that what's proposed in 1830 is just that. It's not to take away guns. I think the concern that was raised earlier was with illegal guns. But we must marshal all the resources that we can, because every waking moment that passes, there's a life in jeopardy, and we've got to take action to save it.
Amen.
Thank you very much. Thank you for being here and for your testimony. Members, we're going to go back into session. We're back on the bill. There was a motion that was made to roll this 1 week to make some changes. Sponsor, do you have any comments you'd like to make before we proceed?
I just want to say I want to thank you all for your indulgence today and allowing my guests to speak before you. I know it took a lot of time, so I greatly appreciate you all for that. I plan to fix that line to take away some of your concerns, and I want to reiterate, this bill is not to take away guns. I'm a proud gun owner. It is to ensure that folks who shouldn't have them don't have them, and we can come up with youth intervention programs to take a multi-agency approach. Thank you all for your commitment, and I support your motion to roll it 1 week.
All right. Members, without objection, we will roll House Bill 1830 1 week. Next item on the calendar, House Bill 2034 by Representative Harris. You have a motion and a second. There's an amendment code 13511. You wish to proceed with that amendment?
Yes, Chairman. Yes.
Okay, there's a motion and a second on the amendment. Go ahead. Leader Lamberth.
Mr. Chairman, I want to apologize to you and to the sponsor. I've spoken to him beforehand. I'm 20 minutes late for a meeting that I had. I had this meeting scheduled till 10:30. We should have scheduled it to 11. I'm going to have to step out. I don't know how that affects our quorum or anything else, but I did want to apologize to both the chairman and the presenter of the bill, because you've done a lot of work on this based on some questions I asked last week, and I deeply appreciate that. But I do apologize. I thought we were going to end a little earlier than we did today. So, Mr. Chairman, I apologize for that. I'll need to step out. And, sir, I apologize to you as well, because you've made some vast improvements on this bill. I don't know what will occur in committee today, but you've definitely improved the bill. Thank you.
Thank you.
Chairman Curcio.
Thank you, Mr. Chairman, and again, all due respect to the presenting sponsor here, but I would make a motion we adjourn for lack of time.
Okay. Motion has been seconded. Any objection? Seeing none, we are. Before we adjourn, we will roll all remaining bills on this calendar to the first of next week's calendar. Any objection to adjourn? Seeing none, We're adjourned.